to add intensive outpatient treatment as a condition of that probation and a $100 VOP fee. This is a guideline sentence. You score 40 points, Mr. Heaton, which I want to bring to your attention. At 40 points, even a technical violation of your probation would add 6. That puts you over that magic number of 44, which means if you, even a technical violation, you would score prison. Do you understand that?
Yes, Your Honor.
I'm trying to impress upon you the seriousness of making sure that you get you through your probation this time. All right, Mr. Heaton, I need you to speak with probation behind you. Then you have 30 days to appeal the judgment and sentence of the court.
Thank you, Judge. That's all I have.
Have a good day.
You too.
Ms. Rivers, I think you're lined up.
Yes, Your Honor. Mine are in custody.
I think that's what
Oh,
he's saying.
sorry.
Yes.
Yeah.
Yeah, please.
What did you want to do, Mr. Porter? They didn't change their mind.
What do you think?
I'm sorry?
What do you think, Bush?
I would just go ahead and take it.
Yeah.
Yeah. You can get more at a VOP hearing. You can get more time at a violation of probation hearing. Okay. Is that what you want to do? Not really, but yeah.
No, I do the same thing. I don't know. It's okay, Sorry.
Your Honor, this is Desmond Porter before the court. 25 CF 137 on a violation of probation. In speaking with him, he is going to enter a plea. He had not, up until this point, he was undecided. And the state had indicated that he had until today, or they would set this for a contested hearing. So I will need to write this up, so if we could have him come back.
All right, we'll pass you, Mr. Porter. We'll bring you back in order to enter your plea after you go over the paperwork with Ms. Rivers.
Thank you.
We'll bring you right back.
Your Honor, this is Adam Richardson before the court, 24 CF 78, 24 CF 2847, here for a violation of probation. We're going to enter a denial at this time.
What would you like it set for?
Your Honor, do we have a docket towards the end of March?
I meant more contested or uncontested.
Uncontested at this point, Your Honor. We want to see if we can try to work something out.
I've got March 26th.
If we could do that, Your Honor, without subpoenas.
All right, March 26th, 9 a.m., no subpoenas.
Thank you. Is that it?
Yes. Your Honor, Mr. Smith is similarly situated with Mr. Porter. He's here on 21 CF 990. This is David Aaron Smith. Your Honor, it was set today for a plea or contested hearing. He's indicated he does wish to speak to me some more. I just asked to put him on for, with Mr. Porter, just to pass him for now.
I'll pass him for a possible plea, but should we keep him here? Thank you, Mr. Smith.
Your Honor, this is John Stephen Smith, 24 CF 258. In speaking with Mr. Smith, I do need to get a few more pieces of discovery together to be ready to go forward. If we could put him on the March date that you had indicated earlier.
26th at 9 a.m., no subpoenas.
Yes, Your Honor.
See you back on that day, Mr. Smith.
Your Honor, this is James Spar, 24 CF 561. This is a violation of probation.
Is Spara?
Spar.
I thought you said Carter. Okay. We can do credit for time served.
Okay. Your Honor, I'm gonna write up a plea on this. We could pass him, so we can write that up. It's gonna.
Okay. We'll see you back in just a little bit, Mr. Spar.
No.
Spar, head on back.
You'll come back.
You'll come back out later.
Yep.
Mr. Spara?
Star, this isn't visitation. You come out, you attend court, you leave, they can visit you at the jail.
And Your Honor, this was our add-on. Get a chance to write up?
I heard Thomas, but is this Parnell?
Cornell Thomas.
I'll do that right now.
We'll need to just pass him for a few moments, Your Honor, while the state is getting the DPA together. Okay, you'll be back.
We got all yours first.
Your Honor, this is Derek Wesley Toller, 25 CF 1800. This is a violation of probation. And I was going to see if the state had an offer.
I'm confused about. Why you that? No, but he was on, is this his first violation of probation? And it's, look, timing. Yes. Okay, so let me just look at this, let me work the score sheet. It should be probably like 9 months.
Your Honor, based on the offer that the state's making, we're just going to enter a denial today.
All right, what would you like to set it for?
Your Honor, if we could just put it on, we could do it at the end of March. That's fine.
All right, March 26th,
That's fine. Thank you.
9 o'clock, that's no subpoenas.
That's correct, Your Honor. That would be for a plea. We're just going to try to get it taken care of.
Mr. Williams.
Yes. Different Mr. Williams, sorry.
Caught in that loop a lot.
I'm just lucky I'm not named Smith.
Okay.
Your Honor, this is Jeremy Williams before the court, 25 CF 702. He's here for a bond hearing. Your Honor, he's been in jail for almost a year. The bond that was given was
Do
$2,500.
you have a case number? I know we had him yesterday. but
Yes.
My docket, I think, wasn't the updated one from late yesterday, so.
Your Honor, that would be 25 CF 702.
Jeremy Williams, here we go. Go ahead.
Your Honor, he's been in jail for almost a year. I think he had indicated 11 months.
You're right.
And he's unable to post a $2,500 cash or professional bond. He does have a father that lives in the area, a father who has had a lot of health issues. He's asking the court to consider giving him a signature bond, even an ankle monitor he's okay with at $1 a day. He just wants the opportunity to get out.
And we set up for trial yesterday, right?
That's correct, Your Honor, and he just told me coming in here that he wants to take it off the trial docket.
Do what? I mean, it's a year-old case. I mean, I'm looking at the arrest report. According to the officer, post Miranda, he admitted he basically did what they charged him with, so.
He admitted to a trespass. He did not admit to
Okay.
breaking anything or, stealing anything.
I gotcha.
I would submit, Judge, that he did it covertly, so presumably he was trying to commit a crime therein.
And,
So what's the status? Have y'all tried to work this
yeah,
case out? It just,
yes, Your Honor. So one of the issues had to do with the score sheet, the number of points, the priors. I did speak to the state about looking into that because they did have a quite lengthy prison offer based on priors that my client had indicated should no longer be scored. And the other thing, Your Honor,
why
is
shouldn't they be scored?
because of the length of time in
I
between.
I understand that, but like, how long has it been?
He said
it-
20 years.
Okay, does that include no sort of supervision or other charges in the meantime?
Well, and that-
clock can get reset for
and
a
that-
number of different things.
Yes, and that is what I did explain to him. Your Honor, the other thing is that he was asking for an 1129 offer, but at this point, the state's not been willing to do so. This is the one where we depose the officers, but the alleged victim lives in another state, and we've had multiple attempts in trying to depose him, and that has been unsuccessful.
I submit that we could probably work it out on Monday. 3-2. I'm not saying that it's going to be what he wants, but we'll move the needle.
I just think as far as the issue with bond, he's got a criminal record, and obviously he scores prison. He's got a $2,500 cash or professional bond, which is $250 to a bondsman. I don't think just reducing it for that reason is sufficient. So, I mean, we can come back on Monday, see if y'all get it resolved. If you don't, I'll certainly potentially entertain again the bond issue, but see what happens Monday.
Yes, Your
Thank you,
Honor.
Judge.
March 2nd.
Judge, this is William Cohen. He's got a case, new law violation scheduled for arraignment on 3/5. We'd like these two to just track together, so I'll enter a denial for him today.
We'll put it on 3/5 then.
Yes, sir. I'm
I
going to
was checking to see if an information had been filed, if we could take care of that, but it hasn't, because it's for next week.
He wants me to bring a bond hearing, but that would be the next opportunity to have one set, so I anticipate we're going to be in that day anyway.
All right. March 5th at, we'll just put them at 1:30. If it's going to be a bond, let's move it till 9.
Yes, sir. All right, Mr. Cohen.
Thanks, sir.
Judge, we're looking at different programs. The PO's recommendation was Keaton. We're looking at some others. And so I'm going to ask to continue them again without subpoenas. We've got the Project Hope application in, we just don't have a response.
Did you have any objection to continue with
No
those
objection to
subpoenas?
continuance.
All right, Let's do March 26th, 9 a.m., no subs. Thank you, Mr. Lawrence.
Judge, my understanding is that the monetary amounts have been paid at this time. I can explain the language that I think suspected getting the no bond instead of the usual on a monetary. I talked with probation. I think probation's okay with just, if he's reached the end of his probation, going ahead and terminating it. If not, leaving him back on probation. Sir, do you know if he's hit his termination date yet? or- No?
Termination date's 11/3/20.
Yeah.
Are you okay with just dismissing the violation since he's now
Here's the
paid
issue,
up?
Mr. Williams, he just went on this probation in November, right? He got a downward departure based on the need to pay restitution.
Yes, sir.
He didn't do that. And then, I don't think I have to say the quote out loud as to what he's attributed to being said about this issue. It was several curse words saying basically, I'm not going to do it.
Judge, when that took place, he's still on the phone with the probation officer. He's hanging up the phone, talking to his family. What he was saying was directed at the family, and the phone hung up before the end of the sentence, which was in time. So it was
I'm not bringing this up because I think that the delicate sensibilities of a DOC probation officer were offended. What I'm saying is, he's refused to do what, the reason he got a downward departure.
And what,
And then these are just the allegations.
yes, sir, yes, sir.
But I just want to make sure that it's
Can I
spelled
say
out.
something?
So you can talk to your client about it if you'd like, because he seems to want to say something.
I'm sorry.
Just happened.
He's fine.
It is.
Oh, sure.
So it says that he's supposed to terminate 29.
According to Aaron Gogley, he is supposed to terminate in like 4 or 5 days.
All right, Judge, I don't have any issues with him telling the court what he wants to tell the court about it. It's a little bit further background on
Raise
it.
your right hand. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name, please?
Joseph Michael Lally.
All right, Mr. Lawley, pull that microphone to him a little bit.
Yes, sir.
There's a lot of ambient noise right now. Go ahead.
In the beginning, I had a different probation officer, and I explained to her that I had a broke back and stage 3 cancer, and I had applied for my SSI. She said that it wouldn't prevent me from being violated, but if the case came up, that she would present my paperwork, and that she had understood that I needed a little bit of leeway with the money situation. And over the time, I had discussed with her how I was going to come up with a payment. All of a sudden, my probation officer changed, and she had called me over the phone on my birthday, told me that I had missed all my payments for that month, and she didn't understand why, and didn't care to hear my explanation. She said I had 5 days to pay it, and that's where the conversation came in. Like I said, it was my birthday, and my mom was sitting right beside me, and that's when I was like, I've got to pay this, blah, 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 and the conversation had, I thought, ended over the phone, which apparently it didn't. But we still came up with the money within the 5-day mark that she had gave me. That being said, the whole time I was trying to stay in contact with her, but I wasn't getting any contact back from the probation officer until I sent the confirmation that the money had been paid. She had told me the next thing that I needed to do was immediately come into the office, which I told her that my next scheduled appointment wasn't for 2 more weeks. And she said she wasn't going to go back and forth with me. It's my job to get to the office when she said so, which at that point I explained to her I have a broken back and stage 3 cancer, and it's 30 degrees outside. I might have a hard time getting there. She said that's not her problem. So I borrowed a bicycle from my next door neighbor and still made it to the appointment and brought the information where I had paid the money, even still being unprepared for making that day and it being 2 weeks ahead of time. I was not trying to avoid any of the obligations. I was just assuming that, like the first probation officer said, that I had a little bit of leeway with the health conditions that I had.
You provided any proof proof of these things?
My mother is in the court behind
Have
me,
you provided any proof of these things? Isn't your mother?
and we
No,
gave.
Judge, it's not here for a contested.
I understand.
I sent my DD 214 to the probation officer in the beginning, and I also gave the medical record from my doctor stating about my cancer and my disability, and I also sent the confirmation of the money that we had paid before I had even went to see the probation officer. I hadn't seen her at all until she violated me that day. That was the first time I ever seen her.
So how much restitution's been paid at this point?
It was 300 that she told me I was behind. We made sure we paid the entire 300 to catch it up because I was unaware that I had already been violated. She told me I had 5 days. We paid it within the 5 days.
So he still owes the balance of the restitution, Judge.
100 plus.
Yes, sir.
What do you want to do today, Mr. Williams?
Judge, I'm just, if we can't dismiss the violation, then go ahead and resolve the case, but I'd like to see him get restored so that he can continue to fulfill his obligations to the state's amenable to that.
Probation confirm any of what's been said here today as far as, number one, that he's caught up on the restitution payments of $100 a month and the medical issues?
Medical issues, Your Honor, I'm not sure of. He's not my case. Trying to look at it. I was looking at his case notes.
Judge, I may have a copy of the receipt. Let me see. Okay. Judge, I'm also being advised that the mother's in the courtroom. I know we're not here for a hearing, but if the court needed to hear from
Well, I understand. I mean, I want actual objective evidence of the things.
her. But he's indicating also that he thinks, ma'am, could you? Do you have the confirmation on it?
Confirmation number, I do have my ticket.
Judge, you want me to have her go get it and we can recall it?
I mean, I need something. I mean, if probation can confirm that they have the paperwork that shows these things, and
There was one $300 payment made, Your Honor.
I understand the payment. My second question is there confirmation of the medical issues that he's claiming?
I see where he told Ms. Gologly that he's working on getting his SSI, but there's no proof of medical documentation.
Sent to Cynthia Brandt in the very beginning. We sent them. I even brought one of them in person, which was my DD 214.
All the DD 214 is your release from
It was showing. I was medically discharged from the military is what that shows because of my back being broken. And then later on, I got the cancer. That's where the paper for my doctor was submitted.
And that's, I just want to see something from a doctor that says that. No offense, Mr. Lally, but,
She has it on her phone.
well, I'm not going to look at someone's phone.
No,
The
the
documentation in the vehicle brings up-
paper is what I was just referring to, not the thing.
Judge, I can have her email it to me. I can print it off at the office and bring it back up later. I was, at this point, just asking
Asking what?
if we could resolve it with a dismissal.
I understand, but I need proof of these things.
I understand, Judge, I understand.
I mean, it's not that I don't take people's word for it, but when the situation is that you scored 22 months in prison, Mr. Lawley, and the reason that you're not in prison for that is because you said you were going to pay this restitution. The victim in the case said, I need the restitution more than I need him to go to prison. And
Yes, sir.
then if it's not being paid,
Yes, sir.
I need to know an actual reason, and I need documentation of that reason.
Well, I'm going to be able to continue to pay it on time now. Like I said, I was expecting to wait for my Social Security to kick off.
I
and
understand
I
that.
thought that's what I was allowed to wait on.
But you were required to pay it at $100 a month. You didn't do that until you got arrested.
Right,
According
'cause,
to everything I've heard.
yes, sir.
So that's a violation of your probation.
Yes,
Now,
sir.
Am I going to mitigate that issue and possibly even dismiss your violation if I see, hold on, see, you're waiting to talk instead of just listening to what I'm saying to you, Mr. Lawley. If I get proof of what you're telling me, depending on what it actually says, not what you say or what your mom says about it, but what is your actual situation from a medical doctor, I'll read that and then potentially make a decision that you're going to like. But I have to have the proof.
Looking at his payment history, it's the same date as his arrest date. So I'm guessing someone made the payment the day he was arrested by his VOP.
Yes, that's whenever she told me I had the 5-day mark, and we made sure it was paid by then, and that's when I told her, I sent the confirmation number in, and that same day, she told me to come into her office, which was 2 weeks before the scheduled appointment. But I came in anyway thinking that she told me it was to clarify the payments and how they needed to be arranged, because my first paper told me $57 a month, and I brought that and showed her, and she explained that all my stuff wasn't listed on the paper that I had previously from the first probation officer, and she printed me out a new form.
It was $57.
It was showing that it was $57 a month that I needed to make sure I paid.
Well,
And
you signed a plea form, and I talked to you about it, where you said you agreed to pay $100 a month just for the restitution.
right, I wasn't quite sure why the $57. I even asked her, and she said that it
Probably
could
to pay
change.
off your court costs.
She said it could change later and all that, which it obviously did. The new probation officer told me it was going to be $167, which she gave me a full printout that I didn't have prior and explained to me.
All right, so how are y'all going to get me the proof of this? Again, today's not a hearing, but if you can email it to Mr. Williams, they can send it to me, and I'll take a look at it. You know, I'm not trying to be a monster about this, Mr. Lally,
Understand,
but I
sir.
got to have proof. That's what courts are for.
I understand, sir.
It's not just about, well, this guy said so, so it must be true. And frankly, they like probation said, you have a DD 214 on file, and that says you're released from the military. It doesn't tell me the details of it, though.
It was a medical discharge is all because of my back being broke.
I understand that, but does that?
It says on the DD 214,
All right,
yes, sir.
Mr. Lally, I'm going to let them send it to you. You don't seem to want to hear me talk, so I'm trying to ask questions. I'm trying to do what you want me to do,
Okay.
and you're interrupting me as I'm trying to explain what my thought process is. And again, I'm not going to go back and forth with it. Just provide me with the proof. Otherwise, we can set it for a hearing.
All right, Judge, you want him to remain, and
If y'all can get it to me today, then get it to me today. But I just,
ma'am, do you think you can get that copy? What he's looking for is the medical stuff. The simplest might be for you to just bring it up here. Okay, depending on when, is it over here at North Okaloosa? Oh, okay then. Just email it to me? Yeah, just email it to me.
we'll bring them back up at that point. As long
All
as
right,
you get it to me, just forward it directly to me, Mr. Williams.
Yes, sir.
Once you get it, I'll take a look at it right here. You know, shouldn't take the electrons very long to get from there to there to here.
Yes, sir.
So
Yes,
let's
sir.
just go ahead and do that.
All right, and we'll bring you back out.
Yeah, she did. She moved their address in Discovery's Old Bethel. Who's the victim? Yeah. No, Holly Smith is some girl's daughter. She's not the victim of the case. Hope Gilbertson's the victim. Hope Gilbertson moved.
All right, Judge, this is William Michael Matthews.
I can provide it in receipt.
Here for a bond hearing. The defense's witness is present.
My dad Bel Air.
Where the GPS showed.
Yeah, she was.
Going to be Tammy Matthews.
So I'm saying, what I'm saying is, at the time that he.
Your Honor, the state, I think there's a bond hearing filed in a case that I'm currently on, but the other one is with Ms. Basso. I spoke to her about it yesterday. I think she's planning to be here today, so I've asked to pass it until Ms. Basso arrives.
Now I know there's allegations.
That's fine, Judge. I want her to hear the witness.
Okay. All right, we'll bring you back,
Or what I was
Mr.
talking about
Matthews, once
yesterday.
the other prosecutor's here.
Okay, we'll bring you back out in a bit.
And there's a lot of other court going on today. I've got lawyers coming from everywhere.
Yes, sir.
Do you want me to provide you the reciprocal for the witness?
Yes.
Okay, I'll do that, so that you can talk to her.
I think the best way, in case you don't know,
All right, Judge, I'm going to enter a denial from Mr. McCarthy if the state hasn't.
evidentially on that one count.
I'll relay that offer to him.
Sure, that's
So,
right.
by then, if you were to have
Basically, he's been serving a 5-year DOC
on that
sentence.
one count.
Sounds good.
VOP on a worthless check.
And he's been in jail now.
Can you tell me the case number? I'm sure it,
Oh, yeah, it's 2014, actually have two cases, 2014 CF 1748 and 17 CF 2324.
the offer would be to adjudicate, revoke and terminate and credit for time served.
Why didn't?
They'll revoke and terminate your probation, adjudicate you guilty, and you'll just have time served.
Yes, sir, I mean, done with it.
That means you're done with it, yes, sir.
Yes, sir.
All right.
Yes.
Judge, I'll need a couple of minutes to go over the,
Write it up, we'll bring you back, Mr. McCarthy, you'll resolve it today.
I'm going to see
He
you.
just has to write it up, he'll come back and talk to you, then we'll bring you back out.
Judge, when I looked up Mr. Mobley to go see him, I showed him as out. So let's pass him, let me go meet with him in the conference room. I was at the jail until about 9:30 last night.
No problem, we just passed a lot of cases, it's fine, things are getting done, but he's gonna
Yes.
come back and talk to you, and you'll come back out, Mr., is it Mobley or Mobley? Mobley, okay. Probably ask every time.
All right. Morning, Your Honor.
Morning.
Your Honor, this is Mr. Tommy Allen before the court on his VOP charge. We'll enter denial at this time, Your Honor. He's also set for an arraignment later this afternoon in 26 CF 238. If an information's been filed, if we can go ahead and enter a not guilty plea, we can take care of that as well, Your Honor.
Information was filed on 2/12 in the 26 CF 238 case, is possession of controlled substance, third-degree felony, possession of paraphernalia, first-degree misdemeanor.
Yes, Your Honor. We'll plead not guilty this time.
What would you like them set for?
Do you want it to track the miscellaneous date or the pretrial conference? What is the court's
Well, it
preference?
depends on if you want to set it for a contested hearing.
No, Your Honor.
If not, we'll just put it on the pretrial.
I would ask for the pretrial, then I don't want to set for an evidentiary hearing at this time because I have to look at the new law and look at the discovery on that.
April 29th at 9 o'clock for pretrial for both cases.
Thank you, Your Honor. Go based on what we talked about. Your Honor, this is Mr. Stephen Arnett before the court in 25 CF 492. Your Honor, this time we would like to enter a plea to the bench, or an admission to the bench on the following violations of probation, Your Honor. Mr. Arnett would admit violations 1 to the court, 3 to the court, 4 to the court, 5 to the court, and 6 to the court. The only thing that we are not admitting to the bench at this time, Your Honor, would be violation 2, the GPS violation. If the state wishes to pursue that, they certainly can, and I believe they are going to. But the others, Your Honor, we are entering an admission to the bench at this time.
Two questions, Ms. Leone. Number one, what is the state going to do to count 2? Are y'all going to pursue it? And second question, what does he score?
It doesn't score a minimum presumptive. As far as the first question is concerned, I discussed with Mr. Maddox. He's supposed to provide me with reciprocal discovery.
Yes, and I will.
However, just to be clear, I was asking to still set it for a contested evidentiary on that one count. There is not plea admitting. But in the meantime, if I can work out the last count I want to go forward for, then it will become just a sentencing.
I believe we're both comfortable with March 25th, Your Honor. I will provide the reciprocal discovery immediately today, a name, a phone number, and then as soon as I can get it, an address for the witness that I talked to, Your Honor. And then we can address everything on the 25th. The only other thing I would need to do is potentially obtain some character letters that my client provided me some names for.
You're saying the 25th. You mean the 26th?
Yes, I do, Your Honor, the 26th. And I will reach out to them and see if they are amenable to doing so, which I should be able to do by the 26th.
You want to enter the plea today? Do you have that written up, or you just want to bring it in on that date to do everything?
If the court is comfortable, yes, that we can bring it in on that day, do everything. That'll give me enough time and the state enough time to review the reciprocal. Mr. Arnett, we've discussed this extensively. There's, we're not going back on it. So he will enter the plea to the violations discussed on that date, and then we can do a sentencing. That would be fine.
And it would be at 2 p.m., please, Your Honor, because I will have witnesses for either the sentencing or also the evidentiary.
Sure.
All right, so let's go March 26th, 2 p.m. with subpoenas, if that's what you decide to do.
Yes, Your Honor.
Otherwise, he's going to admit to everything, other than 2.
Correct.
I get your court.
Yes.
Thank you.
This is Mr. Arp, Your Honor, before the court in 22 CF 1833. Your Honor, I'm asking for a continuance without subs at this time. The state did amend its affidavit, so he's now facing additional violations, Your Honor. I need some time to investigate those. I will do so. I would ask for the 26 without subs.
State, any concern with that?
Oh, I'm so sorry.
March 26th without subpoenas?
No, Your Honor, I would, well,
Apparently, there's a new affidavit with new
is there a new
violations.
affidavit?
Two
That's
new
what I'm.
violations, yes.
Mr. Roberts filed them, I believe, either late last week or early this week.
It's the 17th. It looks like an amended was done.
Yes, because I inquired with him yesterday, and I thought the defense did not have that amended affidavit. I knew of the existence. You have?
I do.
So I would ask to set it with subpoenas on the 26th.
I would just ask for additional time to investigate, Your Honor. Set without subs on the 26th. At that point, set it just like we intended to do today had there not been violations. Set it for a hearing after that. It's plenty of time to investigate it, Your Honor. The allegations are contact with the deputy's son, or a trooper's son, excuse me, that certainly needs to investigate. I do not have his actual affidavit. I have the affidavit of new violations probation. I don't have the actual statement that I thought you said that he had wrote.
He wrote it with, I understand that he wrote it with probation. I can ask for a copy.
Yep.
However, we also have photos. It's not just a contact with
I
one
guess what he's
child.
saying is he doesn't have those
I don't,
things.
yeah, I don't
No, no, I'm explaining because he said the allegation is that he had contact with one child. I'm just specifying it's multiple
Additional?
children. Oh,
Okay.
yeah. I think that a month, today's the 26th, we're a month away. I think it's enough time to investigate. It's a VOP, it's kind of straightforward.
I don't
understand,
necessarily
but-
disagree.
but
It's straightforward. I don't have anything
He
that
doesn't
she's.
have the discovery yet. Why should he have to set it for a hearing when he doesn't even have discovery of new things that were just filed last week? I mean, I don't understand the state's position as to why you won't let him have a continuance.
I thought he had, and he would have enough time until the 26th.
Assuming you've given him the evidence, but that hasn't been done yet. I'm not saying you're late or anything. I'm just saying it's a
Understand.
new allegation that was just filed last week, and he wants the discovery before he sets it for hearing. I'm not even sure I understand why you'd object to that. March 26th without subpoenas.
Thank you, Your Honor.
Nine o'clock.
Ms. Booker? Hi, Ms. Booker. Your Honor, I believe I'm going to have a conflict in Ms. Booker's case, but for purposes of today, I can enter a denial for her. I will get word to the court as soon as I find out whether this conflict exists.
They're technical violations on a VOP from, she's on probation for.
Yes, Your Honor,
4.5 years.
she is a potential witness, a potential defense witness in another case of mine. I do believe that could create a complication.
That's understandable. I just want to make sure there's something there.
Yes, Your Honor.
I don't usually inquire in, but I also don't want Ms. Booker sitting around waiting to find out what might happen with a case.
Certainly.
So I would suggest let's get that decided quickly.
Yes, Your Honor.
March 26th without subpoenas, 9 o'clock.
I'll let you know, okay? If not, you'll get RCC.
What's that?
Yeah, don't, but you know. Mhm. Your Honor, this is Mr. Kamar before the court in 25 CF 1806 for a bond hearing. You have a copy of the motion and the associated medical records, Your Honor, for the court's benefit.
I think that was just emailed over yesterday, right?
Emailed over this morning.
This morning?
Yes, Your Honor,
Oh.
6 a.m.
Wait a minute. Who's this?
Mr. Camarda, Your Honor.
I think I got
Christopher
sent over
Kamar.
this morning was Dunmore.
Dunmore was set. I thought this one was set as well. Did you set it for 3-5?
No, not set,
Oh.
sent as far as the documents that came over this morning.
Okay.
If you have a copy, I can take a look at it. I can do that.
Yes, Your Honor, I do.
Does the state have a copy?
The state's reviewed the medical records.
State have a position.
The state objects.
Says he's a 123-year-old man.
Notice.
Yeah, I
that.
noticed that typo.
Twice, it says that.
I think it says it throughout.
I haven't got all the way through yet, but I've seen it twice already.
Your Honor, I'll give the court several minutes to review before I make argument.
And I can't tell if that's a name that it mentions, like the wrong name. I don't know if it's a condition.
This transfer,
Yes, I don't know.
I've never heard that term before, but it sounds like it could be. All right, go ahead, Mr. Newman.
So, Your Honor, essentially, the arguments are primarily the same as last time. The reason these new medical records have been provided is one of the court's primary concerns where the previous records I provided to the court were deficient in actually explaining the circumstances of the brain injury. I believe these records are much more clearly diagnose the brain injury and also indicate that he suffered several symptoms, including altered state of consciousness, motor deficit.
Give me his case number, I'm sorry, because we just put it
Yes, Your
over
Honor.
from yesterday, right?
25 CF 1806.
Go ahead, I'm sorry.
They're fine, Your Honor. Altered state of consciousness, motor deficit, sensory deficits, and cognitive and behavioral deficits. It also does recommend follow-up treatment in these medical records, Your Honor, as was previously testified at the prior bond hearing, which I'd ask the court to take judicial notice of that testimony that was made there. He's missed appointments. His mother was trying to get him to follow-up treatment. His mother indicated that he could stay with her, and get him to court and make sure he gets to court, gets his treatment. I don't think there'll be any further issues with Mr. Camarata, Your Honor, and I don't think the jail is the best place for him to be right now, given that he needs this treatment, and now there's documented evidence that he suffered this traumatic brain injury. Now, that being said, Your Honor, we recognize that ultimately it's his responsibility to get to court, and given the court feels it needs to impose some sort of some sort of incentive, more incentive to get him to court, we don't necessarily oppose some sort of cash or professional bond in this case to incentivize that, Your Honor. But I do believe there's been a significant injury that's been suffered here. I don't believe he can get the treatment in the jail, and that the jail is the best place for him at this time, Your Honor. I do believe he'll continue to come to court and has a strong interest in resolving this case and getting the treatment that he needs. And so for all of these reasons, Your Honor, I would ask the court to either set a bond or release him on some sort of signature.
State's response.
Judge, the accident that Mr. Kamar is referencing is from him not wearing a motorcycle helmet. If you look at his record and take judicial notice, a few days before that, he got tickets for speeding, reckless driving, stuff like that. So he's violated probation with a new law violation. Though I feel for Mr. Kamar's injuries, I'm sorry that happened to him, but he should not benefit for his recklessness. And that's the state's position.
I don't know that he has a violation.
Okay, not violation, but he was on bond.
Okay.
All right, what are his follow-ups, Mr. Maddox?
Sorry, Your Honor?
What does he have to follow up on with his?
So I don't know the exact specifics of what he needs to follow up. However, I do know he had an appointment scheduled on December 22nd, which he missed, and that at least an appointment is needed to see what treatment is needed, Your Honor. And I can't speak to exactly what that's going to entail because there aren't any records as to that because he hasn't been able to obtain the follow-up treatment that he needs.
Say that he got arrested on December 22nd is why he missed?
For trespass, yes, that's
Right.
correct.
And he's already
Was
pled.
there any sort of traffic citation or anything related to this car accident, this motorcycle accident?
Not that I could find, unfortunately, Your Honor. It's very strange that I wasn't able to find some sort of incident report or traffic report on this case, but I checked everywhere on the clerk's website and even asked his mother if she had, records, or him, if Mr. Kamar, if he had records of some sort of, explanation of the incident, Your Honor, and I could not find one. The best explanation of what happened seems to be in the medical records that I provided to the court, Your Honor. Significant collision.
So,
But I'm showing a traffic ticket from, I can't see the date, 'cause for some reason I can't pull up the citation. And 25 TR 8318, where he pled guilty to driving 91 in a 55 in seemingly September, which is right around the same time frame. So I don't know if that's related to this.
Speak to that.
not sure, but the reason that the state I don't believe this is speculation, but he doesn't have a license because he pled guilty to possession of controlled substance last year. That may be why the cops weren't called for this vehicle accident. Because when you look at, he was also cited for not carrying a license.
I would object to that, Judge. There's no evidence to that.
Then I believe Your Honor could take judicial notice of him not carrying his license.
Oh, here, in the clerk system, I'm seeing a lot more.
So that's why the state's position is what it is.
On September 13th, he's in a SUV doing 91 in a 55. That wasn't the motorcycle accident. I guess my concern at this point, Mr. Maddox, is I know he missed an appointment, but I'm not sure what the appointment was for or what else needs to be done. I mean, I understand he was in a serious accident, which I haven't really been shown was it his fault or not, but he was driving at a high rate of speed on a motorcycle within a week of doing 91 in a 55 in an SUV. So I've got concerns about his behavior before the accident. And he's here because he was on pretrial release and has now pled to another crime while on that pretrial release where he was found in someone's fenced-in backyard, which is consistent with other loiter and prowling convictions that he has.
The court's concerns on that are well understood, Your Honor. The thing is, as the court points out, we can't know what treatment he's going to need. We as lawyers can't speculate until he actually gets the appointment and gets recommended for treatment or not, and he hasn't had the opportunity to do that. That fact is.
But you've given me
Parent
medical
here.
records that shows that he was in a bad accident, but you haven't given me anything that says this is what needs to be done. So it sounds like you're speculating that more further treatment's needed.
Well, no, Your Honor, he tried to get an appointment, as his mother testified, on December 22nd, which he wasn't able to do because he was incarcerated. And then, I mean, quite frankly, Your Honor, I can't prove a negative.
You're not proving a negative, Mr. Max. You're trying to tell me that he needs treatment. So you need something that says he needs to come in for this particular treatment or this sort of evaluation.
At the end of the medical records, it said he was supposed to follow up with.
Where is that at? Because frankly, I've got a little concerns about medical records that might have the wrong name on portions of it and also says he's 123 years old.
So if my memory serves me correctly, I believe this appointment was in Gainesville, Florida. Am I wrong?
Don't recall where the appointment was set for. Hold on, I'll let you
He
speak.
was treated at UF Health Shands in Gainesville.
In the end of the medical records, Your Honor, on page 12 of 13, it recommends follow-up. It says you should call as soon as possible for follow-up with Dr. Foote or a team member in the neurosurgery clinic in 4 to 6 weeks. Please feel free to contact us via my chart as well. The referring physician there appears to be Jason Stringer. Also, Your Honor,
Judge, the bottom line is he had an appointment and he chose not to travel to Gainesville he was in somebody else's backyard instead of getting his treatment. So now he's asking for treatment while he's incarcerated.
He's incarcerated. He missed the appointment.
I think what Mr. Sprouse is indicating is he wasn't in Gainesville for the appointment on the day of it because that was the day he committed the new law offense.
Or the day before, so he committed
Well,
the,
I think there's a difference,
yeah.
because if he was here and not 300 miles away in Gainesville, that would show he wasn't actually trying to go to his appointment, and so I think that's an important distinction. So what date was his appointment, Mr. Maddox?
Yes, Your Honor, that's what I'm pulling up right now.
I believe the testimony was the 22nd, or the proffer.
That's correct. Yes, Mr. Sprouse is correct. It would have been in Gainesville on December 22nd. 5 in the morning, around 7:25
I'm looking
a.m.
at the affidavit of complaint on the trespass charge, which is the new law violation. It says 18th of December.
A couple days before.
So it was 4 days before his appointment.
I mean, I don't want to I don't want to diminish, especially when he's pled to the trespass now, that crime, Your Honor, but, I mean, we're talking about a trespass in someone's yard that he pled to versus trying to help somebody get treatment for a traumatic brain injury. Now, I know, and the court is correct, I've not provided anything specific as to exactly what treatment is needed. I can't do that. I don't have records that would indicate that. Those are all the records that I've been provided and have. But if he's able to set up an appointment, we would know what treatment is available to him, and my client would be willing to pay a cash professional bond. My client would be willing to report to pretrial services, and if the court is concerned with some of the behaviors mentioned, he'll even wear a GPS monitor. I'm just trying to facilitate the possibility of treatment, given treatment is needed. I don't want to represent, and I suppose I should retract my statement to say that definitively he needs some sort of treatment. I suppose I cannot say that. But I would think that there's enough evidence here, Your Honor, certainly to say well beyond speculation that treatment would almost certainly be needed here. Anybody who has a traumatic brain injury would naturally try and follow up on these appointments.
I'll reinstate his previous bonds, but with a GPS monitor, $1 per day, pretrial supervision, he has to check in once per week. I think this should go without saying, but I'm going to say it anyway.
Yes, Your
No
Honor.
driving of any vehicles.
Okay, don't drive. Sir, yes, Your Honor.
Sir.
Yeah, unless you
But I'm not going to entertain this argument if there's another law violation.
Oh, that's without a doubt, Your Honor. I won't even
If
put it
there's a
before the
violation of
court.
his pretrial release again, he can expect to finish out his case in the jail.
Yes, Your Honor.
Yes, sir.
Thank you.
All right.
Thanks. So, yeah, call him.
You can have this back, Mr.
Call him
Maddox.
or what?
Your bonds are in state.
Eugene Carter?
Good morning, Mr. Carter. Your Honor, this is Mr. Carter before the court in 16 CF 288. At this time, we'd enter a denial.
All right, what date would you like to put it on, and do you want subpoenas?
326 without, Your Honor.
No objection.
All March 26th without subpoenas, 9 o'clock.
Yes, sir. Your Honor, this is Ms. Cox before the court in 20 CF 3038. Your Honor, I'm going to have her evaluated for path of grace. Ms. Dana Claus also met with her. She would really like to at least try and give her the option of getting treatment. Not sure if the state will ultimately be amenable to that, but I know Ms. Claus wanted to reach out. So, Your Honor, I am asking for a continuance in this case to do that. I would ask for 326 without subpoenas.
Without objection.
March 26th, 9 a.m. without subpoenas.
Thank you, Your Honor.
Thank you, Ms. Cox.
I'll come see you.
Make sure you follow up with your evaluation.
Hey, Mr. Dunmore. Oh, yes. Your Honor, we're here for a bond hearing in Mr. Dunmore's case.
Go ahead.
Your Honor, actually, upon review of this matter, the bond hearing, I looked at the underlying facts of the case. It is a grand theft auto charge. We've been unable to reach the victim and the alleged victim in the case, and on top of that, there are some statements the victim made that are not consistent with what's gone on in the case. All in all, I'll be announcing a dismissal.
Dunmore, and this is 25 CF 1078.
Yes,
All right,
correct.
Case is dismissed.
Yes, sir. Thank you.
Good luck.
Thank you. Appreciate you.
You're welcome. Your Honor, this is Mr. Foreman before the court in 21 CF 1984. Your Honor, I am asking for a continuance in this case. Your Honor, I'm doing some research on one of the violations.
What date would you like?
326 without, Your Honor.
Date?
What is this one?
Done.
Mr. Foreman.
Oh, an offer?
No, just, he wants to
Oh.
continue it to March 26th.
Oh, that's fine. No objection.
March 26th, 9 a.m. without subpoenas.
Yes, Your Honor.
All right. Thank you, Mr. Foreman.
I'll come see you, sir. Hey, Mr. Franklin. Your Honor, this is Mr. Franklin before the court in 24 CF 151 and 15 CF 1363. Your Honor, at this time, we'd enter a denial without subpoenas and ask for March 26th. I haven't been in contact with Mr. Franklin's brother, and he sent over some stuff that I would like to review.
March 26th, 9 o'clock, no subpoenas.
Yes, Your Honor.
Thank you, sir.
Yep, he sent me this stuff. Yep. All right. Correct. I do have one out of custody. Rebecca Glover? Or I should ask Your Honor. Your Honor, sorry if I call the out of custody.
Sure, that's fine.
Okay. Your Honor, we do have a resolution in this case, if I may approach.
Who is this?
This is Miss Rebecca Glover, Your Honor, before the court in 21 CF 939.
All right, bring it up. Ms. Glover, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Your Honor, she has a,
I see. So just do your best, and I'll indicate what your answers are to me, so at least the record's clear. All right, Ms. Glover, you're here in 21 CF 939 on a violation of probation. I've been handed a plea agreement that calls for you to admit your violation. Your probation will be revoked and terminated. Credit for time served, $100 VOP fee, $150 cost of defense, and adjudication of guilt. Is that the agreement that you've made with the state? Okay. You're indicating yes. All right. And did you go over this form with your attorney? Yes. And are you satisfied with your attorney's advice? All right. Are you under the influence of any alcohol, drugs, or controlled substances? No. Are you currently suffering from any mental health issues? No. Anyone forced you to enter this plea? Has anyone promised you anything in return for your plea? No. Okay. And again, the court's just giving the answers because you're shaking your head and nodding along due to your voice issue. All right. Do you understand there that you'd be waiving any potential defenses that you may have in this violation of probation if you enter this admission? Okay. And what is your plea to the violation of probation? Are you admitting or denying it? Admitting. All right. I'm going to accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, revoke and terminate your probation. Credit for time served, $100 VOP fee, $150 cost of defense. I'll give you 90 days to make payments, to set up a payment plan on your costs that you owe. Otherwise, it'll go to a civil lien. This is a guideline sentence, as you scored 35.6 points. Was she adjudicated on the underlying?
I believe she was, Your Honor, but she's certainly being adjudicated now.
Well, I just want to know if I need her fingerprints.
I believe she was, Your Honor. Were you adjudicated yet?
Yes, okay. All right. Thank you, Ms. Glover. You have 30 days to appeal. Previously adjudicated is what they did.
Should be everyone I have.
Mr.
All right.
Rare, do you have one, I think?
Thank you, Your Honor.
For the record, Your Honor, David Rare for Mr. Marcus Hamilton in 24 CF 2014. It's a VOP case. We're set today for arraignment. We're entering a denial today. We do have a bond hearing set for March 5th at 9 a.m. I spoke with the state this morning. We're not going to be able to reach a resolution today, and so we'd like to leave it set for the March 5th bond hearing date.
March 5th, bond hearing. Regardless of what happens at the bond hearing, what do you want it set for? Just so it has a control date. I don't want it to be a situation where the bond hearing gets canceled or something and he has no court date.
Oh, the 26th?
Only because it's happened before. So,
We're
not on his
calling the
case.
docket or something?
Yeah, I just wanted like a status. Just
Tentatively set for the 26th in the morning without subs, and then,
I think that's fine.
yeah.
All right, March 26th without subpoenas, but we'll have the bond hearing next week on the
Yes, Your
9
Honor.
o'clock.
Yes,
All right.
thank you.
That's all I have, Your Honor. Thank you.
All right,
See
thank you, Mr. Rare. Mr. Kleins? See if this is helping out, but someone on the line, I'm assuming it's going to be Mr. Reed.
You are in the meeting now.
I don't know why that has to be the loudest thing. Go ahead, Mr. Kleins.
Your Honor, this is Mr. Fell. I know Ms. Leone filed her response to our motion, I believe earlier this week or late last week. As we've previously informed the court, this is a pure matter of law. I don't expect to make any arguments today. I just wanted to be clear, though, that Mr. Fell, from day one, has never challenged the actual sentence that's being imposed. Just, he doesn't want to be in a position where the court thinks he's trying to withdraw a plea or anything. He's
I
not.
understand.
So, but the state did file its response. I'm providing Mr. Fell a copy of that response, but I will defer to the motions filed by the parties.
The state will be comfortable with that, Your Honor, that the court decides based on the pleadings.
reading the things over. I know I read Mr. Fell's motion, and then I think you redid it, Mr. Klein's, but I know you sent your response a couple of days ago, but
I know how you, I know.
pretty much ever since, so I just haven't had a chance to go through it. I mean, obviously, I'm very familiar with the Gould case and what the issue is. I just haven't had a chance to read through what you've provided at this point.
I'm fine with that, Your Honor, the stated.
Your Honor, the only thing I would ask is that Mr. Fell remain in the county jail until the court renders a ruling, just in case there's something that I need to go over with him on, maybe however the court rules.
This is what I'll do to hopefully make sure that happens. I'll put it on March 26th at 9 o'clock for the pronouncement of my ruling. I expect I'll give you a written ruling ahead of time, because I would want to do a written ruling on this anyway, even if I announced it today. For that hearing on March 26th. And then obviously if I issue the written ruling, Mr. Klein's, and y'all are satisfied with that as far as doesn't need any more hearings, then we can do something to have them set.
And I would, just for Mr. Fell's benefit, I would be unavailable on the 26th. Mr. Fell, I'm under a subpoena to testify in a trial that day. So, but if the court issues the ruling beforehand, I will come talk to you and go over it with you. And then the 26th is basically a status date. Okay.
I'm with you. If you do issue anything on this, would there be any chance that it would be able to be pushed up sooner?
What would be sooner?
The rendering of all this.
Well, as soon as I issue an order, that would be the end of the issue, unless your lawyer decides he wants some sort of rehearing or reconsideration type of motion or something like that, but I can't say that. I mean, I'd like to get it done quickly, but unfortunately, this is kind of our, lack of a better term, hell week. I've been in this chair pretty much the entire week, and unfortunately, I didn't have a chance to read the state's response. I'm very familiar with the issue. I've issued an order that was on a similar issue before. I just wanted to read it to see if there's a different argument that's been made at this point. And frankly, I always have to follow up to make sure there's not something new that's come out since. Because I know one of the issues that changed post-Gould case is the legislature changed the law about 6 months later. So I just have to go through all the dates and make sure everything is the same before I can make a similar ruling, if that's what I decide to do. But Mr. Fell, what I'll do is making myself a note. Then I'll go put it on I have a whiteboard in my office where I write down all the things that I still need to finish up. And I'll put you on there this afternoon, and I'll hope to, depending on how our trials go over the next couple of weeks, I would expect I'll have it done before March 26th, but I like to give myself a deadline just to make sure that it gets done in a timely fashion.
Yes, sir.
As soon as I receive the ruling, I will bring it up to the jail and provide you a copy, and we'll talk about it. Okay. Your Honor, this is Jara Frasier. She's on today's docket for a motion. I was reviewing the motion. I inadvertently called it just a motion to reduce bond. It was a motion to set and reduce bond, obviously. Situation with Ms. Frasier, Your Honor, is in 25 CF 1634. That is the violation case. Ms. Frasier has been ordered held without bond. She does have a new law violation in 25 CF 2375. There is a $10,000 cash or professional bond on that case. Ms. Frasier has no prior record other than these two cases. If she is released on bond, she would live at the Florida Avenue address in Crestview. She has lived in this area for about 35 years. She states that she has no prior failures to appear. She's never been on probation, so she's never been accused of violating it. The thing that really stands out to me with Ms. Frasier in this situation, Your Honor, is number one, she's on probation for animal cruelty in the 1634 case, and one of the conditions of supervision is that she not provide care for or own any animals. She's living on this property, and this is all mentioned in the violation report, and she's living on this property. I think in June, probation comes out, and there's a portion of this property, there's a shed, and they built a little fence around the shed so there would be no I guess, contact between Ms. Frasier, Ms. Hahn, and the animals that are in the enclosed portion of this fence. And the probation officer pretty much told the two of them, like, this will pass muster, but it's not a good idea. In September, Terry Frasier gets arrested, and he's the one who owns these animals. Terry Frasier gets taken to jail, and about a month later, Ms. Frasier gets charged with the allegations in the new law violation, which is the 1176. I'm sorry, that's the wrong motion here, Your Honor. In the 2375 case. Well, the question that I have is, if one of her conditions of bond is that she not care for animals, then how is she being charged with not caring for? She basically is being put in a position where either she violates the terms of her supervision and provides care for the animals, or she doesn't, and then she picks up a new charge. So
Let me make sure I understand what your argument is. Once Terry gets arrested, right?
Right.
Then someone has to take care of this animal?
Well,
these animals? Is that what you're?
Well, the thing is she's basically put in a position where if she provides care for the animals, then she's going to be violating a term of her supervision, but not picking up a new charge. But if she abides by the terms of her probation, then she picks up a new charge and she gets violated.
Can't you just call animal control or PAWS or whoever has the contract for that particular area?
Well, a further question I have is she legally required to? Because there is some language in the violation report saying, well, she's leasing this property, so therefore she has a requirement to provide care. I don't know if that's true. I don't know if that's legally accurate. Number two is, why is Terry Frasier not being charged with animal cruelty? He's the guy who owned the animals. He gets arrested. He's literally surrounded by jail guards all day. There's a parade of law enforcement officers going in and out of ACR. Why is he not being charged with not notifying, hey, somebody's got to call PAWS? You know, I agree.
Question for law enforcement or the state attorney's office. I don't make charging decisions.
I understand. The point I'm bringing up, though, Your Honor, is she just was put in a position where I don't think that she could succeed here. She doesn't have any record. These aren't her animals. They're in a portion of the property that is fenced off from the rest of the property. As far as I know, there's no allegations that she was going into that portion of the property. I don't even know, frankly, if she knew there were animals there. I mean, I think probably it's fair to assume, given the fact they built a fence around it and there was discussion with the probation office about this, we are simply asking the court to exercise its discretion, set a $10,000 signature bond on the violation case, and reduce the $10,000 cash or professional bond to a $5,000 cash or professional bond in the new law violation. We have not taken depositions in that case yet. Again, she has no prior record. She's never failed to appear because she's never been in court before other than these two cases. So that's why we're asking the court to consider this. Ms. Frasier does want the court to be aware. I'm not saying this is why the court should grant this motion, but she does have multiple sclerosis. She does have some medical issues. But I'm primarily relying on the situation she was placed in and the fact that she has no prior record.
All right, Mr. Sprouse, state's position.
State objects. The reason being is that this is a technical violation that could easily been avoided by not having dogs on the premises. Saying that you're leasing a shed to somebody and now that's not your responsibility, for one, not habitable. The shed doesn't have running water, maybe it has electricity, doesn't have air conditioning. So that is, I think, disingenuous to say that somebody else is responsible for it because they're living in the shed. They fenced off the shed for the dogs. It's obvious that there's dogs in there. There's been conversations with Ms. Frasier and the probation officer saying that's not a good idea. Her not being violated at that point, the state is not sure why that didn't happen because it's included in the violation report now. So it's a constant thing where this person should not have dogs. The new law case, a dog died because of her abuse. So the
I don't have any information about the new case because it was a direct file case, so there's no report that I can read.
correct, it's located in the violation report. It should say, maybe it doesn't say that the dog has passed, but I'd proffer that that is what she's charged with in the new case.
I don't have any of that information, so I was not aware of that.
So it's clear that she cannot abide by this court order saying that somebody's locked up in jail should be charged with it. No, that wouldn't be willful. She knew that there was dogs there. There was options. They could have hired a dog sitter. They could have called paws. They could have done all of these things except letting the dog die. There were multiple dogs on the property. The conditions that the dogs were in were deplorable. At first, they said a 16-year-old was taking care of the dogs and was sleeping in the shed, but once it was brought to their attention, that is the most disgusting bed that we've ever seen, then she retracted her statement. So she's not being truthful during this whole process.
How big is this property?
It's 3.5 acres, but it's a lot of trees. I can find somewhere else to stay if need be.
In reading this, so they're within 2 weeks of getting on probation for this. There's the nephew with the dogs, and that's when they first put the fence up, is what I'm reading. Seemingly that situation is ended, and then a couple months later in June, let someone else come on the property with animals. And then once he gets arrested and there's no one to take care of them, I think there's a different action that should be probably handled than trying to do something, because what ends up happening is these dogs are in deplorable conditions again, and now the state's alleging one of them has died, which is news to me. So I set the $10,000 bond on the new case, and you're entitled to a bond on a brand new case. You're not entitled to a bond on a VOP. Your motion's denied.
Your Honor, this is set for April 7th for an evidentiary hearing, I believe.
We're doing an evidentiary hearing on April 7th.
I know yesterday we had talked with Ms. Hahn's attorney. That's when
April
I.
9th is.
9th.
Yes.
Okay. And that's the
Sometime-
evidentiary hearing for both?
I believe.
If that's how defense wants to.
Well, I was under the impression that Ms. Hahn's attorney that we had discussed setting it for an evidentiary. I mean, I'm fine with continuing it. The new law violation is the basis for the.
I thought that case was on this docket today, too. Because that was Mr. Williams just got assigned to it like a couple of days ago.
Right, that's
Or
why.
this month.
That's why we put it out to.
We can leave it on. I'll defer to however. I just remember sitting in court yesterday, and that's when I jumped.
I don't
on
think
this.
it was set for an evidentiary hearing
Okay,
for that day.
that's fine. That's cool then. I'm good with that.
Okay.
Yeah, Bonnie Hahn was not.
Okay. All right. Well, then if we can just continue Ms. Frazier's cases to the April 29th docket. I mean,
I have no objection to that.
All right, April 29th for both of Ms. Frazier's cases at 9 o'clock. It's the VOP and the new law violation. What's this, has the new law violation been to arraignment yet? Yes, it was arraigned already. All right, so both cases will be April 29th, 9 o'clock. Obviously, Mr. Kleins, if you'd like to have an evidentiary hearing on that, just get it set on a miscellaneous.
Yeah, no,
date.
I just only said that because I was under the impression yesterday it had been.
I think Mr. Williams found out about the case yesterday.
Okay.
He was, because it had been Mr. Nopes, I had signed an order.
Right, I knew there had been some shuffling around with the attorneys.
We're moving forward with Bonnie Hahn first, is that's what the state announced at the beginning of it, because we knew that the shuffle of the attorneys was going to happen.
It says iPad. All right, who's on Zoom with the, oh, there you are, Mr. Ramey. All right, I just want to make sure it was you that was here. It just says iPad. Let me get the jail to, or the court security to pull your people. And once Mr. Kleins finishes up, you'll be next.
I just have Cheyenne Davis, Judge.
I understand, but they're coming out of the jail in a certain order. I'm going to get them to bring your
Yes, sir.
people. All right, go ahead, Mr. Kleins.
Your Honor, this is Casey Kemp. I talked with Mr. Kemp, number one, at the jail. I know when he was last in court, there was discussions about his medical records. I don't think they're relevant. I don't think they're necessary.
You might have to remind me more about that.
So, Mr.
This is the
Kemp.
third case this morning. We've talked about people's medical records.
I know. So Mr. Kemp was being driven back from Phoenix House, and there's an allegation that he hopped out of a van. I know last time he was in court, there was discussions about getting his medical records and this, that, and the other. I went to the jail and I told Mr. Kemp basically, look, nobody's accusing you of falsifying the medical condition that resulted in the discharge. I don't see how they're relevant. Nobody's saying that that's not true. So Mr. Kemp does want me to try to get the GPS data from this car. I don't know if I can, but I will try. I would ask the court to put this on the April 9th docket for a evidentiary hearing with subpoenas. However, I did talk with Ms. Flowers this morning, and the state, Mr. Kemp is interested in going back into a program. He's not just trying to get off of supervision here. So I want to backstop it with a definite hearing date. However, I'm going to talk with the state before that and see if we can get some sort of a resolution that the parties can live with that would result in Mr. Kemp going back into a program. So we are trying to resolve this short of the hearing, but I also don't want to just kick this 2 months down the road or something like that. I mean, I can be ready by April 9th.
State?
I jumped up because currently it's mine. It's going to be Ms. Flowers's. Is it going to be a hearing or not? I was confused.
I mean, I'm going to say prepare for the hearing, but however, I'm going to talk to Mr. Kemp. If we can get some sort of a program that you guys can live with and get him back into supervision, that's fine. That's what we're trying to do. You know, I talked with Mr. Kemp at the jail. He's interested in getting back into a program. I mean, he was discharged for a medical condition from Phoenix House, you know.
We should set it for a hearing because the likelihood of this getting resolved is pretty slim.
Want to say April 9th at 2 o'clock?
That's fine, Your Honor.
April 9th, 2 o'clock for an evidentiary hearing.
I'll talk to you at the jail, all right?
Yes, sir.
All right, man. April 9th. Today's February 26th.
So it's another 30 days.
Something like that, yeah, something like that, a little bit more. Your Honor, this is Christy Rainey. She's also on the afternoon docket. She's on the morning docket for a VOP arraignment. If we could, we would go ahead and enter denials on the VOP cases. Would the court entertain the bond motion now, or does the court want to bring her back at 2 o'clock?
Are y'all ready to handle the bond motion? Rainey?
Sorry, it was on for a bond hearing today, wasn't it?
It
I
is.
think it's just set for the afternoon, but she's here in the morning for her arraignment.
I'll pull it up. Yeah, just give me a second and I can, if the court would allow, just 1 second.
Yes.
Pull up the. I'm ready.
Go ahead with your motion then.
Sure, Your Honor. So Ms. Rainey was arrested on 2 new charges, 25 CF 2461 and 25 MM 3310. There are bonds on those cases. She is not asking the court to do anything with those bonds. She is asking the court to consider exercising its discretion, setting a $2,500 signature bond for each of these 2 cases. So for each case, so to be $5,000 total in signature bonds. If she is released on bond, Ms. Rainey would live at 964 Valley Road in Crestview. She has lived there for about 1.5 years. Her husband owns the property. He's lived there since 1990. She has lived in this area for about 14 years. She works in retail and housekeeping. She is wanting to enroll in higher education and pursue a degree in psychology. She does have 1 prior failure to appear. She states that she showed up to court wearing shorts and a particular judge wouldn't let her in. So that's the nature of that failure to appear. So we're not asking.
Judge Ward, yes.
Yes. As soon as she told me how that happened, I correctly guessed the judge. So we're not asking the court to do anything with the new law violation bonds. If she wants to bond out, she'd have to post cash or professional bonds on those cases. But we are just asking the court to consider signature bonds for these 2 VOP cases.
And,
Go ahead, Ms. Williams.
Your Honor, the state would object to a bond in the VOP cases. She committed a new law while out on bond and is not entitled to a bond, and that would be the state's position.
That's my concern. The allegations in the 2461 case is that they made contact with her regarding an arrest warrant. She's alleged to have given a false name, and then when questioned about that, she ran. It doesn't exactly quell my fears about flight risk.
And alleviate your fears I can't alleviate your fears, or, I mean, all I can do is, just, I don't even know the right word for it, is I'm going to remain in the area. I mean, I don't even know what to say.
The thing I would point out to the court, Your Honor, is number
Yes,
one,
the-
she would be reporting to probation if she was
Right.
released. In the violation
In
report,
pretrial?
it does say that on 12/9/2025, she did report to the probation office. Granted, it was 6 days late, allegedly, but she reported, you know? I mean, she was maintaining contact with her probation officer, although not the most perfect contact. So I definitely understand the court's concerns. Reviewing everything before today, honestly, that kind of jumped out at me too, is these are not the greatest allegations if I'm asking for
The
bond.
issue is, I mean, she just went on probation November 25th. In that time since, concerns about reporting to probation on time and 2 new law violations within basically a month. Where one of them, the allegations is giving a false name to law enforcement and then running from them. So I've got real concerns about flight risk concerns. So based on that, I'm denying your motion to set bond on the VOPs. What is she set for?
Your Honor,
So, I mean, it's kind of bizarre.
Ms. Rainey currently scores a presumptive DOC sentence, so I don't want to bring her back on Monday. There's not going to be a resolution, so if we could just leave this on the April 29th docket, and we will proceed accordingly.
You can't purchase a gun legally if you're a convicted
To,
felon.
She's a convicted felon, that's why you got the charge, ma'am.
Yes, sir, I understand that, but I purchased, I walked.
I would stop talking about that. You may be admitting to some sort of other federal firearm charge by what you're about to say, so I would suggest you don't talk about it. You're already on probation because you pled to that charge.
Am I able to withdraw my plea now that the case is reopened?
You have to do that within 30 days. All right, thank you, Ms. Rainey. 4:29, 9 o'clock.
Morning, Your Honors. This is State of Florida versus Cheyenne Davis. She's got 4 case numbers, 24-1535, 24-1060, 23-2826, and 23-2800. She's been referred to drug court. Drug court coordinator contacted my office yesterday, indicated that Ms. Flowers had indicated she was working on the plea documents. Should have those out by Friday of this week, and they're looking to set her for the drug court plea on Wednesday of next week.
Yeah, so Mr. Ramey, I've got it done. I just need.
Ms. Flowers, it's usually better to speak into the microphone.
Oh, sorry. Mr. Ramey, yes, I got your, the plea agreement. I didn't realize she was on our docket for today, but it's done. I'll send it back to
Okay.
you. And then, did they enter the plea in drug
They
court?
do it in drug court.
So
in
I'll
front of
get it
Judge
back to
Ward.
you, like, by the end of the day.
Okay.
Okay, sounds good. Thank you, Ms. Flowers.
And then you'll have drug court on Wednesday with Judge
Hopefully,
Ward.
this has been it's been an ongoing thing since, for.
All I can say is bring you there. If no one does, then someone has to tell me why it wasn't done.
She had cases in multiple counties, so I think Mr. Ramey's worked
Oh,
really
Bay
hard to
County
get that.
too?
Yeah, it was, yes, sir, it was, Bay County, which they are doing a global resolution.
Okay. All right, so that'll be next Wednesday. What is that, March 4th? They'll put you on the drug court docket.
Okay.
All right, thank you,
Thank
Ms.
you.
Davis.
Thank you, Your Honor. May I be excused?
Yes, sir. Sorry for the wait, Mr. Ramey.
That's okay, Judge. Great to see you, sir. Bye-bye.
I keep forgetting you're on the docket until I flip through and I see you. I'm like, oh, I better check Zoom.
Well, about another month, I'll be there in person, I
Another
hope,
month.
so I appreciate allowing me to appear by Zoom.
All right, thank you, sir. Have a good day.
Bye-bye, you too.
All right, Ms. Rivers.
Your Honor, Mr. Porter just needs a moment to sign his plea agreement. All right. 54 months. I did put on their credit for any time served.
At 54 months?
Yes, Your Honor.
Handwritten score sheet like this in a while. All right, Mr. Porter, can you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Desmond J. Porter,
Date of birth.
12/25/1992.
All right, Mr. Porter. You're here in 26. Wait, is that right? 25 CF 137. And it's a violation of probation on 2 third-degree felonies. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement for your violation of probation. Between you and the state, there would be an adjudication of guilt, 54 months in the Department of Corrections, which is what you score. Credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Have you had a chance to go over this with your lawyer?
Yes, sir.
Do you need any more time to do so?
No, sir.
Did you understand the agreement?
Yes, sir.
Did you sign the agreement?
Yes, sir.
All right. And are you satisfied with your lawyer's advice and representation at this time?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've announced?
No, sir.
Do you understand by entering an admission to your violation of probation that there won't be a hearing where the state would have to prove that you violated your probation?
Yes, sir.
You understand that you're waiving all potential defenses you may have to that violation?
Yes, sir.
And And you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country.
Yes, sir.
All right, and Mr. Porter, what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty, revoke and terminate your probation, 54 months in the Department of Corrections, each count to run concurrently.
Yes, Your Honor.
Credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Do you want to send those to judgment? All right, those will be sent to judgment. This is a guideline sentence. Guidelines were 54 months. All right, Mr. Porter, I need to tell you that you have 30 days to appeal the judgment and sentence of the court. Thank you. Previously adjudicated.
She got 20.1 as well. So revoke, terminate, probation, $100, all that, and 20. Your Honor, this is David Aaron Smith before the court on 21 CF 590.
Okay. I understand. Mr. Smith, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your name and date of birth, please?
David Aaron Smith, 4/12/82.
Mr. Smith, you're here on a violation of probation in 21 CF 590 on 2 third-degree felonies, which are punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call for you to admit your violation. You'd have your probation revoked and terminated, 20.1 months in the Department of Corrections with credit for time served, $100 cost of prosecution, $100 PD fee, and a $50 application fee, and those will go to civil lien against you, correct? Okay, is that what you want to do here today?
Yes, sir.
All right, Mr. Smith, did you have enough time to go over this form agreement with your lawyer?
Yes.
You need any more time?
No, sir.
All right, did you understand and sign the agreement?
Yes, sir.
All right, now are you satisfied with your lawyer's representation and advice in this case? Yes?
Yes, sir.
Okay, sorry, I couldn't hear you. That microphone got turned down. All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promised you anything other than the terms of the agreement I've read?
No, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
All right, you understand that you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and what is your plea to the VOP? Are you admitting or denying that?
Admitting.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given, revoke and terminate your probation, and sentence you to 20.1 months in the Department of Corrections with credit for time served, $100 cost of prosecution, $100 PD fee, $50 application fee. Those monies will be sent to a civil lien against you. This is a guideline sentence as you scored 20.1 months. All right, Mr. Smith, I need to tell you you have 30 days to appeal the judgment and sentence of the court. Good luck, sir.
Thank you. Thank you.
Your Honor, this is James Spar before the court on 24 CF 561. He just needs to sign the agreement. Reinstate probation. Mr. Spar will not go back on community control. Court costs. It's considered a modification.
Explain. Reinstate to probation, but not community control.
I wrote it like 3 times trying to figure out the way to put it. Okay, so when he was violated, he had several days, like 4 or 5 days left of community control.
I understand 4, thank you.
And the community control officer said, I just want him to do credit time served for the remainder of that portion of the community control and then just move straight over to regular probation. Because he's got a community control followed by probation sentence.
Okay, and in the meantime, he spent how many days in jail?
How many days have you been in jail so far this time?
This time?
Uh-huh.
Let's see, since the 20th of last month.
35 days, 5 weeks or so in jail because of it. All right, Mr. Spar, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, can you state your full name and date of birth, please?
Full name is James Franklin Sparrow, 7/1/1966.
All right, Mr. Spar, you're here in 24 CF 561 on a violation of probation where you're facing up to 15 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handed a plea agreement between you and the state that would call for you to admit your violation, be credit for time served, reinstate you to probation, not community control. So to the extent it needs to be modified, it will be regular probation going forward for the rest of the duration of your probation. $100 unless there's another violation, Mr. Sparrow. Let's not do that. $100 cost prosecution, $100 PD fee, and a $50 application fee. Is that the agreement you've made with the state, Mr. Sparrow?
Yes, it is.
All right, I'm going to do this. All right, have you gone through this form with your lawyer?
You read
Yes,
it?
sir.
Have you read it?
Yes, sir.
Okay. Do you need any more time to talk to your lawyer about it?
No, sir. I'm
Did you
satisfied.
understand and sign the agreement?
Yes.
All right, and are you satisfied with your lawyer's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you to enter this plea?
Nope.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, do you understand that you're waiving any potential offenses and there's not going to be a further hearing on this?
Yes, sir.
Okay. All right, and what is your plea to the violation of probation? Are you admitting or denying it?
Admitting.
Yes.
Admitting.
Admitted.
Okay. All right, I'm going to accept your admission as freely, voluntarily, knowingly given, adjudicate you guilty, modify your probation to be regular probation, not going back to community control, credit for time served, $100 cost prosecution, $100 PD fee, and a $50 application fee. I need you to speak with probation, who's sitting there behind you, Mr. Sparrow.
Yes, sir.
And you'll have 30 days to appeal the judgment and sentence of the court.
Yes, sir.
Thank you, sir.
Okay. So, if you change your address, you got to notify the clerk of court. $25, $150, $150. Okay. Tells you where to pay it. Okay. Go to pretrial services. 4 or 5 or tomorrow morning. Okay. And Yeah, I'll date it for you. Nope, yeah, he's just gonna talk to you about it for a minute.
So this is Pernell Thomas Jr., 25 CF 2225. I've been handed a signed deferred prosecution agreement. Y'all need me to file this with the clerk? Okay. And his case will be taken off the docket. Make sure you follow through with your deferred prosecution agreement, otherwise you'll end up coming back to court.
Yes, sir.
All right, thank you.
Any questions, call, okay?
That's correct.
Did you send that email to Mr. Sprouse as well?
Let me check. I think I did.
It did. I think it went. It went to him.
Okay.
Mr. Sprouse, did you get the email regarding Mr. Lally?
The records?
Yes.
Yes, I did.
Okay. Change your position anyway.
It does not.
This is what I'm going to do, Mr. Lally. I've read it. I'm not going to go into your specifics of what it says, but I've reviewed it. I don't like the attitude that you seemingly, at least allegedly, gave to probation. It's probably why you're standing there wearing a jumpsuit right now. But what I'm going to do is dismiss your violation of probation. But I expect they're going to file another affidavit if you're late and you don't talk to them about it first. But I also would indicate to probation if there is a violation for a monetary issue, even if it's on the same restitution, that any efforts he's given you to tell you why he couldn't pay be included in such affidavit. And to be honest, Mr. Lally, on financial issues, I often don't put someone in jail. But it was the attitude that you expressed towards him that led me there. Okay? So let's not do that again. All right.
Thank you,
He's
Judge.
dismissed. Overstates objection, I'm sure.
Judge, we're ready to proceed. Present.
This is the bond hearing for Mr. Matthews?
That's correct, Judge.
All right, how,
Your Honor, he's a violent felony offender of special concern.
okay.
And
That's
he
the
has
first
a
I've
new law
heard that.
violation.
Possible Judge, I'd still like to go ahead and take her testimony today. Largely, I'm trying to get her information before the.
You agree that he's a violent felony offender of special concern under 94806?
Judge, I don't have any independent knowledge on that.
Can you provide that basis, Ms. Basso?
Your Honor, I'm actually, I was going off of the probation report. I'm just checking that statute myself since the court asked.
You have that, sir?
For our system, Your Honor, whenever we enter in all of his stuff, it auto-generates into the violent felony offender.
Your computers are never wrong, right? I'm not saying they are in this situation. I just like to know the basis. I just know the basis, want to know the basis of what particular count it was that, I'm assuming it's based on a prior, because the charges he has in these two cases are not qualifying offenses, but so I'm assuming he has a prior qualifying offense.
She's recanting what she told the officer. He was living there the whole time.
Doesn't matter, he's still busted.
Sure, I'm just,
He didn't register that address.
He didn't register that address?
He never updated his registration like he claimed he did. Okay, I'm trying to do two things at once here. All right, I'll just list the charges here somewhere. I think if he's a sex offender. Yeah, it's not. 847.0. It's 135.
y'all know where his case is that requires him to register? Was that an Okaloosa
Your Honor, it was
case?
actually in Holmes County.
Okay, that's, I just haven't seen a case that would show that he should even have to register. I'm not saying he doesn't, I'm just
Well,
saying
he
locally.
is a designated sex offender.
Oh, it's from Holmes County?
Yes, sir. I know it's a solicitation, which is 847.0135 sub 3, and transmission material harmful to minors, 847.0138 sub 2. Or is a registered sex offender. I believe just because his sex offender matches. Your Honor, I believe it does state if he is a registered sex offender under 943.0435, and under supervision, then it would qualify as well, according to my reading of the statute, and he is a sex offender.
So what are we gonna do, Mr. Williams, if I can't?
I understand, Judge, but I still want to get her testimony out, where the
For
prosecutor
what
can hear it.
purpose? I understand what you're trying to do,
She's
but
recanting what she told that officer. She says he was living there the whole time. The state just informed me that they thought that he had not registered that address, yet that's where the officer went to verify his location, so I'm finding that was correct. So his mother is here. His mother allegedly told the officer when he came out to verify the address that he wasn't living there. In actuality, he and his father had had a disagreement. His father had become very angry, and she was hiding him on the property. He never left the property.
can I, so you wanna put her on the stand?
Yes, sir.
Have her swear to tell the truth, subject to perjury, to tell me that she lied to the police?
Yes, sir.
And for what purpose today? If I can't even give him a bond?
Judge, otherwise, I guess I can set her deposition, but they've been trying to get him out of jail since his arrest.
I understand that, sir, but you're asking me to basically tell someone to get up on the stand and commit a crime. Either admit that they lied to law enforcement during the course of a criminal investigation, or potentially lie here in court
Judge, that's
by
not-
giving contradictory stories, and the evidence is for nothing other than you want the prosecutor to hear it.
Judge, I don't represent her, I represent him.
Well, but
And
you're not
I'm
giving me a
asking-
reason why I should even hear the testimony anyway.
I'm not asking her to commit a crime, I'm asking her to tell the truth. If the court's not inclined to hear it, then,
You haven't given me a reason why I should hear any testimony in this case. Because we're here for a bond motion, and he's a violent felony offender of special concern, so I can't give him a bond.
Judge, then I'd ask that we treat it as the safety of the community.
Okay, then we can potentially do that. You ready to go forward on that today?
No, Your Honor.
In terms of the state's handling, can I inquire what the difference is between a bond hearing and the safety of the community hearing? In terms of state preparation for that. I don't understand why we can't still proceed.
Awesome.
Your Honor, he is not entitled to a bond because he is a violent felony offender of special concern.
And you asked to set a bond, right?
Yes, sir, that's how I styled it.
I think the difference in preparation could be you filed for one thing, and now that we're here, you're asking for something different.
In terms, though, of preparation, what's the difference?
I may need a
She's going to
witness, Your Honor.
cross-examine the witness. She's going to point out the same things that the court just pointed out and see if the witness changes her story.
The fact that the witness may or may not have lied to law enforcement really has nothing to do with the danger to the community. I mean,
Well, I think the issue would be then, the state would have to prepare to have the law enforcement officer testify that says, this is what she told me.
Judge, everybody agrees that that's what she told him. She agrees that that's what she told him. She's not going to claim to have told him anything differently. She's going to say that she was not telling him the truth at the time because of issues in the familial relationships.
Your Honor, if I may, the defendant himself actually told law enforcement he'd been staying at his girlfriend's house for a period of time that would have required him to register that address as a temporary address, which he also did not do. So there's a little bit more to this than just
So,
whether or not mom was telling the truth or
As
dad
far
was
as
telling the truth.
corroborating one side or another of potentially mom's testimony is going to be the defendant's testimony saying that she told the truth at the time, which means that if she takes the stand and says the opposite now, it's potentially, again, perjury that you're trying to put on the stand.
No, Judge.
Motion for bonds denied.
Thank you, Your Honor.
I think you're pushing a line, Mr. Williams. I think you know what the situation is, and you're asking for the court to hear potentially perjured testimony on an issue that's not even before the court. You can respond if you'd like.
Judge, I am presenting the testimony that I have been told. It's not my job as the attorney to determine whether or not the witness is telling the truth unless I know the witness is lying, and I don't know that she's lying.
Okay.
So it's denied.
Okay. It's going to be April 29th, 9 o'clock for pretrial conference.
Judge, this is Alan Russell Mobley. We have a negotiated plea in the case. There you go.
It says 11 months, 29 days county jail to do ECLC. Is there no credit for time served? I just want to make sure that's clear, because sometimes y'all...
Judge, we're not waiving credit in this case, and they're not asking us to waive credit
Okay.
in this case.
Because I know sometimes y'all do that when ECLC is involved. I just wanted to make sure I was clear.
Yes, sir.
Correct. We're going off the basis is the probation's recommendation, and they're requesting inpatient, like ECLC. Given what he scores, the state believes it's appropriate.
All right, so it's a downward departure as well.
Yes.
All right, you know how much credit he has?
Yeah, I don't.
Okay. I'm just wondering as far as how far he's going to be able to get in the program.
I should do 2 terms.
Say again.
I should be able to do 2 terms, 3 months piece.
Okay. All right, Mr. Mobley, raise your right hand. Do you swear or affirm the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
All right. Can you state your full name and date of birth, please?
Alan Russell Mobley, 8/26/85.
All right, and Mr. Mobley, you're here in 22 CF 3079, 23 CF 821, 2 violations of probation, for each of which you could receive 15 years in state prison. Do you understand that?
Sure.
I've been handed a plea agreement between you and the state that calls for you to admit your violation of probation, be 11 months, 29 days county jail, comply with the Emerald Coast Life Center program while you're in the jail, credit for time served on each count, and it'll run concurrently, be $100 cost of prosecution or a VOP fee in each case, and $50 application fee to the PD, and $100 each per case for cost of indigent defense. Is that what you want to do here today?
Yes, sir.
All right. Did you go over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just read?
No, sir.
You understand you're waiving all potential defenses to the violation of probation?
Yes, sir.
And do you understand if you're not a U.S. citizen, you could be deported or excluded from the country based on this plea?
Yes, sir.
All right. And what is your plea to the violation? Are you admitting or denying that?
I admit.
I'll accept your admission as freely, voluntarily, knowingly given. Adjudicate you guilty, 11 months, 29 days, county jail, credit for time served, comply with ECLC while you're in the jail. That's to run concurrent between the 2 cases. $100 VOP fee on each case, $100 PD fee on each case, and the $50 application fee. I'll give you 90 days after you get released to go ahead and pay that money, revoke and terminate probation. All right, Mr. Mobley, I'm sorry, this is a downward departure. You scored 14.4 months. Basis for that, Mr. Sprouse?
Uncoerced negotiated plea bargain by the state.
All right, you have 30 days to appeal, Mr. Mobley. Good luck to you, sir.
Judge, that concludes my business. May I be excused for an hour?
Yes, sir.
And prosecutor, do you have a score sheet yet? On the pardon?
Yes, let me print it. I've got it pulled up.
Williams, you can bring up the plea. We'll get started. Is it a guideline sentence? Okay. Oh, boy. Oh, but you said he was serving time in Alabama, right?
That's correct. He
Okay.
served. The event in Alabama occurred prior to these charges.
All right, Mr. McCarthy, can you raise your right hand? You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
John Arthur McCarthy, January the 20th, 1963.
All right, you can put your hand down, Mr. McCarthy. You're here in 2014 CF 1748 and 2017 CF 2324, where you have violations of probation on third-degree felonies, which means they're both punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea agreement between you and the state that he hasn't signed yet, Mr. Williams. No worries.
I'll be here. Shut this all down and leave it here. Take this with me.
Where's sign?
address it. All right, Mr. McCarthy, have you now signed the plea agreement?
Yes, sir.
All right. And do you need more time to speak with your lawyer about it?
Yes, sir.
Are you satisfied with his representation and advice in this case?
Yes, sir.
You know, verify if he was adjudicated on the underlying. It's just, case is that old, I might not be able to find it quickly. All right, Mr. McCarthy, it calls for revoke and terminate your probation, adjudicate you guilty, credit for time served, $100 VOP fee per case, $150 PD fee, and I'll give you some time to pay that 90 days from your release, or you can set up a payment plan with the clerk's office. Are you current? Is this what you want to do?
Yes, sir.
Okay. You have guidelines? Okay. Bring those up, please. Are you currently under the influence of any alcohol, drugs, or controlled substances? Thank you.
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Anyone force, pressure, or threaten you in any way to enter this plea?
No, sir.
Anyone promise you anything other than the terms I just read to you?
No, sir.
You understand there won't be a hearing where the state would have to prove how you violated your probation? And do you understand you're waiving all potential defenses? All right, and what is your plea to the violation? Are you admitting or denying that?
Admitting.
I'll accept your admission as freely, voluntarily, knowingly given, revoke and terminate your probation, adjudicate you guilty. Credit for time served, $100 VOP fee per case, $100 PD fee per case, $50 application fee one time, and I'll give you 90 days from your release to either pay that or set up a payment plan with the clerk's office. Otherwise, we'll be sent to a judgment and could lead to your driver's license being suspended. This is a guideline sentence. He does not score. All right. Thank you, Mr. McCarthy.
Thank you.
Your Honor, may I?
Yes.
So,
Please.
I didn't want to interrupt earlier, and I didn't know if Ms. Rhodes received Mr. Crawford's email. Basically,
I don't know. Ms. Rhodes is unfortunately homesick today.
Oh, sorry to hear that. That explains. He's been communicating with me, saying that he had some major either depositions or hearing, I forgot, in Escambia, but he would like to come here this afternoon.
What are we set for?
Plea. It's a plea.
Okay. We can put him on the afternoon if that's okay with the jail.
Thank you, thank you. Sorry about that.
No,
Your
it's
Honor.
fine.
Yeah, that's the last.
No, I'm just worried about, there's a lot of sick people around us right now. I'm worried about where I'm going. Yeah.
Yeah.
All right.
Judge, there was an issue, I guess we can bring up this afternoon. Cody had asked me to file a motion on the McKinney case. I sent it to you by
McKinney, I did
email.
see that. I'll do my best to get that into the system and get it signed on the stipulation, but as I just said, Ms. Rhodes is out sick today.
Yes, sir.
So I'll do my best while I'm handling court and pretrial detention hearings and everything else.
Yes, sir. I will not be handling the pretrial detention hearings today. May I be excused?
Thank you. No, I'll sign it. It's a stipulated bond motion or bond order. All right, Mr. Hughes, you want to come on up? This is not related to a case that's on the docket. All right, Mr. Hughes.
Yes, sir.
All right. Tell me how things have gone over the past couple of weeks.
I'll be honest, the first 5 days were not easy. I was going through detox. I did try to attend an AA meeting the day after court. I'm an agnostic Christian, so that was a little bit Christian too steeped for me. I have entered into an intense...
Agnostic Christian?
I'm agnostic.
Okay.
Yeah,
but
sorry.
you said Christian after. That's what confused me.
Oh, sorry.
That seemed like kind of an oxymoron.
I'm sorry, yes.
So, I've never heard that term. It's something I've never heard. Go ahead, though, Mr. Hughes.
But I am now enrolled in an intense outpatient program. I've already
Where at?
spoken to a Brightside Health.
Okay.
And I have also spoken to a therapist and a psychiatrist. The psychiatrist decided that I'm not in need of medication for this, but my intense outpatient treatment is 3 group meetings a week.
Okay.
Along with 1 hour of therapy on Wednesdays.
Okay.
And I believe that this is the correct course for me. I do have a copy of the screenshots of the contract that I signed with Brightside.
Okay.
To get into the intensive outpatient treatment. Would you like to see those, Your Honor?
No, I trust you, Mr. Hughes.
Okay.
Okay. So this is what I'm going to do for you, Mr. Hughes.
Sure.
I did a little more research after our issue where you were one of my potential jurors in a civil case a couple of weeks back.
Yes, sir.
And showed up in a status you shouldn't be in, right?
Yes, sir. Absolutely, yes, sir.
I found you in direct criminal contempt for that.
Yes, sir.
I'm vacating that. And the reason why, number one, you were honest with me the first day. You've done what I've told you to do since. But also, in doing my research, because although you were in front of me at that time, some of that evidence is based on what other people told me. And in that situation, I'd have to find you potentially an indirect criminal contempt, which involves me appointing you a lawyer and going through a more formal process. Instead of doing all that, I'm going to vacate what I've already told you. I want you to continue on this path and remind you that I sit in the criminal division as well, so you've watched all morning.
Sir.
And so you see people who've come in front of me and gone to prison today.
Yes, sir.
So I don't want to see you in my courtroom here, unless you want to come watch.
No, sir, I would prefer not to.
Okay. But I want you to stay on this path.
Yes, sir.
And I'm not demanding this or ordering this in any way, Mr. Hughes. But if you happen to send me a letter 3 months from now to tell me how great it's going, or it's not, because I know through my 22-plus years in the criminal justice system that addiction is a problem. And part of recovery is relapse, and we hope that doesn't happen, that you stay strong through it. I know it was a couple of tough days, I'm sure, as you've stated, but I want to make sure that you're staying on that path. So if you happen to send in a letter to my office telling me things are still going well, I'd love to know about it.
May I say something, Your Honor?
Yes, sir.
Actually, this is something that I very much needed to start the process of recovery. Thank you for vacating the sentence, and I appreciate the opportunity to better myself.
Okay. And sometimes we just need that. I think I talked about that when you were here.
Yes, sir.
This is a fork in the road. You've definitely got on the right path.
Thank
I
you,
just
sir.
need
I'm
you to
trying.
stay there, because
Yes, sir.
sometimes
I'm
that's the
gonna
harder
do my
part.
very best.
All right. Thank you, Mr. Hughes.
Thank you, sir.
All right. Good luck with everything.
Thank you, sir.
Yes. Ms. White? I don't know anything about your case other than what the Mr. Deputy Williams just told me. Give me this. Hold on. Give me the spelling of your name. Oh, you got a case number. Never mind. Thank you.
May I be excused?
Yes. Apparently, this was a fugitive warrant. They never picked her up.
Yes, I got arrested January the 9th, and Judge Ward gave me a ROR bond Tuesday of this week. And I'm just showing face today because it
No,
said
I
on my arrest
appreciate it.
report that I had court, so. And then I'm gonna go down there and turn myself in, hopefully next week. I just didn't want to get an FTA.
At that time, Texas was notified January 10th to come get her. Texas has not communicated with OCJ and has not picked the defendant up. Have you attempted to communicate with Texas since you've been released?
No, I haven't. No, I haven't. I just got minutes on my phone. I didn't have them on my phone when I got released.
Okay. I would suggest you take care of that.
Yes, sir.
Otherwise, they may pick you up for this again here.
Yes, sir, I know
and
that.
hold you. So
Yeah.
otherwise, as far as this case, Ms. Flowers, are you familiar with how these work? Okay. Normally, what happens when someone shows up for their court date on a fugitive from justice, if they've been released from jail, the state just dismisses the case because there's nothing to pursue anymore.
Okay, okay.
My assistant, Miss Portera, has been taking care of those, so
Okay.
I can take your name and.
I'll give you the name and case number right here.
Okay.
If you want to look up to see if you're going to enter a dismissal on that.
We'll check at the office.
In the meantime, I'm going to give you another court date just as status.
Okay.
But if the state dismisses the case, obviously you won't have to come back. I just want to make sure it doesn't fall through the cracks.
Yes, sir.
So let's put that April 27th at 9 o'clock. But I expect that the state will take care of it before then. Just make sure you take a look at that before you just show up for court.
Yes, sir. Thank you so much.
All right, thank you, Mr.
Your Honor.
Yes, sir.
Probation be excused.
Yo, yes, thank you.
I don't want to interrupt.
No, you're fine. All right, now we've got more people. What are y'all here for? Oh, okay. Okay.